Hi, I'm attorney Gregory Dell, and I'm here with attorney Stephen Jessup, and we're going to discuss musculoskeletal disorders and long-term disability insurance claims. And Stephen, musculoskeletal disorders is a very broad topic, but basically from the statistics that we've seen covers probably more than 30 to 40% of the disability claims that are filed nationwide with all of the disability insurance companies. And musculoskeletal disorders include spinal disorders, arthritic disorders, knee disorders, shoulders, hips, wrists, carpal tunnel, all of the disorders of the joints of the body. And what we find to be challenging about these conditions is that most people, once they get to age 40, start to have joint disorders and pains. And the question is when do these disorders raise to the level that they become disabling? So in this video, I want to talk about some tips about ways people can go about proving their disability claim and the type of support that and evidence that the disability insurance company is going to be looking for. So when someone calls you with a musculoskeletal type disabling condition, how do you tell them to go about obtaining the evidence they're going to need to prove their claim?
Well, the biggest thing is going to be the objective evidence. That's one of the things the insurance company is going to look for, whether it be MRIs, CT scans, EMG and nerve conduction studies. It's all the diagnostic and objective medical evidence. That's what an insurance company is going to use first and foremost to determine the severity of the condition, and then by way of that determine how severe your symptoms should be. If you have a severe herniation on MRI, they're going to treat that as a little more, disabling than they say would a disc bulge. Even though pain, as we always say, is subjective, only you know how you feel. An insurance company is going to take a look at your objective medical evidence and draw a conclusion as to, how much pain they think you should be in. So first and foremost, really getting yourself set up with those tests that may be done to verify what exactly the problems are and what's going on.
And when it comes to a musculoskeletal disorder, how important is it to see specialists, and what types of specialists are recommended?
Well, it is important, and also under this neuromusculoskeletal disorder, usually those limitations will have a soft tissue component. Like, so you had mentioned arthritis. They do exclude usually serum positive ones like rheumatoid arthritis, psoriatic arthritis. So if you have arthritis and you have one of these provisions in your policy, you want to go to a rheumatologist. If it's potential numbness in your arms, tingling in your legs from something in your spine, orthopedic doctors or neurosurgeons. So you do want to get in with specialists. A big problem a lot of people have is they have these conditions chronically, so they'll continue to work, and they may discuss it with their primary care doctor, and then it gets to a point where they're thinking about filing for disability, but they haven't been able to get into a specialist, and it's not always easy to get in on a referral. So in a lot of cases I've seen, when people contact us when they're having problems, their primary care doctor is taking them out of work for a back problem, but they're still pending visit with an orthopedic doctor, and the insurance companies will point that out as, well, you're not having treatment with a specialist to verify what exactly is happening. So it is important that if you are having these problems, that you also go and see specialists, and ideally you see those specialists prior to the filing of a disability claim.
So a lot of people ask me when they call about a claim, how much scrutiny is the disability company going to put into my medical records? And what really has to be in my medical records? What do you usually tell people when they ask you that question?
I mean, that's everything. The scrutiny is going to be 100%. They're looking for what's in your records and also what's not in your records to kind of draw a conclusion. Mind you, under these employer-provided policies, although they can subject you to an independent medical evaluation, chances are they're just going to have someone review your file. They're not going to have someone examine you. So this person reviewing your medical records is only seeing what's in there or what isn't in them. So it's very important that with your doctors, you're documenting what these symptoms are, the complaints you have, how it's impacting you you at work, how it's impacting you outside of work. You want to be able to tell a story in your medical records so when an insurance company doctor just gets a stack of papers, they can read and they get an idea, all right, this person's had this problem, it's gotten worse, they've done this in follow-up, they've done, maybe some type of injections or physical therapy. So they want to take a look at all the things that you've done. If it's a severe problem that's going to result in disability, normally from an insurance company mindset, you're going to see quite a bit of medical records documenting all the things that, people you've seen and all the treatments you've undergone to try to assist with it.
You mentioned injections, therapy, different types of medications. Why is it important or advantageous for a claimant to follow up with every single one of their treating doctor's recommendations?
Because if they don't, the insurance companies will say, well, your doctor recommended X, Y, and Z, you didn't do it, you didn't take this medication or do this treatment, so it can't be that severe a pain. So they'll always use anything they can to cast doubt on you. And because this idea that pain that you are feeling is subjective, they want to try to punch holes. Well, if it's really that bad, why haven't you done these things? So it's always wise to follow up with doctor recommendations. First and foremost, it can help you, can give you the relief and keep you from having to file disability potentially. But it's also this concept that if you are going to have to file for disability, you don't want to give your insurance company any ammunition to try to, poke holes through your claim.
Another issue that comes up a lot with my clients is they go see a specialist like we've been talking about, whether it's an orthopedic surgeon or a neurosurgeon, and they may get a recommendation for surgery, but the claimant doesn't want to do the surgery. Is surgery required? And if they don't undergo the surgery, is the disability carrier going to say, you're not getting appropriate care and treatment and we're going to deny your claim?
No, it's not required. Surgery is not required or a condition with which to receive your disability benefits. Obviously, surgery it can be major. I mean, there's no such thing as a simple surgery. They say there's a lot of complications that can occur. And depending if it's something like, say, throughout the thoracic and lumbar spine or the cervical spine, a lot of times surgery is a last-ditch effort that the doctors will go to because of the risks associated. So the fact that you have to have surgery actually verifies, that this is a problem. So your complaints of pain should be deemed as more reasonable in light of the fact a doctor is recommending surgery. Your decision not to have it is not something the insurance company can use to say you're not under the appropriate care in this instance.
And you mentioned earlier when we started the video about the chronic nature of these claimants with musculoskeletal issues, that many of them work for months or years with their condition. Some of them have been seeing a doctor, some have not. And then they get to the point where they can't work anymore, even though they've been treating for months or years. And the disability carrier says, well, what changed? Why now can you not work? How does a claimant deal with that particular argument, and how do you advocate for a client to get around the what changed argument and prove that they're disabled at this point?
Well, it depends. It really depends on the case, the occupation, what the exact problem is. But I think you can always start with, if it's been something chronic and it's gotten worse, what objective test can you do to verify if something has gotten worse? Say it's an updated MRI that shows new herniations or more severe bulges or deterioration and degeneration. Well, that's what's changed. It has gotten worse for you. So first and foremost, that objective evidence to see, to be able to compare to prior. Also with the idea of what changed, the counter argument to that is, no, he didn't want to go on disability. This is why this person never filed. They don't want to be on disability. They want to try to continue to work and get through it. And it got to a point that they can't. Generally, though, you don't want to be raising that argument as your main argument. You want to have some rationale, and that's where updated objective testing, getting into your doctors if it's getting worse, and make sure it's being documented. Having a conversation with your doctor about maybe it's time you think about filing. If your doctor says, hey, I think you should take some time off work, it doesn't mean you have to stop that day. And I've had clients that don't want to yet. They try to gut it out more, and it's not working. They get back into the doctor again, and that recommendation is given to stop working. And then there's at least a paper trail and this idea of, a worsening of symptoms. So everything is always going to go back to your medical records, because that's the world that the insurance company is going to live in. What's in there, and like I said, what's not in them.
There's two main issues. People always say, well, if all of my doctors support me and I have 2 or 3 or 4 doctors, how are they possibly going to deny me? And the first thing I tell them is that you should automatically assume that no matter what, they're going to review your medical records. They're either going to use an in-house, meaning a doctor employed by your disability insurance company, or they're going to hire a third-party company to strictly review your medical records only, not even review you or examine you. And the disability insurance company, Steve, as you know, is always going to rely on the opinion of their hired doctor over the opinion of 3, 4, 5 doctors that are treating the claimant. And so that's the first thing. And what that means is that you should know that everything that Steve and I have been saying is your medical records have to be documented 5-star. You have to have great records that show all of your complaints. You have to undergo all of the testing. You have to exhaust all of the therapies, the injections, the diagnosis, the medications, the blood tests, everything your doctor recommends, so that the disability carrier and their doctor can't be in a position where they say you don't have A, B, C, D, and E when you have done all those things. So that's the number one reason. Number 2, Steve, as you mentioned earlier, there's no machine that measures pain. Regardless of all the objective evidence that a claimant has, there's nothing to verify your level of pain, and everyone's level of pain is different. So the disability carriers try to prove that you as a claimant are not credible. And how do they go about challenging the credibility of a claimant so that they can say, look, if you're not credible, then your complaints of pain are not really as genuine as you say they are. So what tools are used by the disability carrier to challenge the subjective complaints?
Challenges to credibility are almost, certainly going to involve either video surveillance or some type of other investigation. Generally speaking, if they don't do video surveillance, and even if they do video surveillance for that matter, they're going to take a look at your online presence, social media accounts, if you have blogs, all those types of things. If they can find information of you, showing you, going out and doing physical activities, as minor as it may possibly be, in our opinion, if they see something that's inconsistent with what you've reported to them, they'll use that to attack your credibility, saying, well, if you weren't truthful when filling out this form or telling us what your problems are, then why should we trust what you're telling us the severity of your condition is? So credibility is going to be video surveillance and some other type of investigative background searching.
And very often in our denials, of course, we always have to deal with the medical evidence that the disability company has tried to raise to challenge the claim. But we always have to deal with some kind of video surveillance or social media presence, like you said, and prove why what's being seen on a video or what's in a social media profile doesn't equate to 8 hours a day, 5 days a week of working. And that's one of the biggest challenges we have when presenting a claim. And also, we get the misinterpretation of the occupational duties and the Dictionary of Occupational Title classifications of sedentary, light duty, medium duty, and basically the disability carrier minimizing your occupational duties and saying if you can sit in a chair for 6 hours a day, then you can do your job. So there's a huge vocational component that has to be proved as well, especially when you have musculoskeletal limitations. The last thing, Steve, which you did briefly mention, and that most group, not most, but I'd say half of the long-term disability policies we're seeing now are these musculoskeletal limitation provisions. What are those in a disability policy?
It's a catch-all way to get rid of you. That's what it really amounts to. It used to be, mental health is the biggest one, limitation there. So under these, and there's different names, but neuromusculoskeletal, soft tissue disorders, what it is they try to lump the majority of pain-related conditions into a category that allows them to only have to pay you a lifetime of 24 months of benefits under your policy. There will be exceptions to that. These policies will say, myelopathies, if there is seropositive arthritis like rheumatoid arthritis and psoriatic arthritis, evidence of radiculopathy. So there are ways to get around that limitation. But just even recently in the past week, I reviewed a policy, and a lot of times it said, we're not going to cover this unless there's evidence of radiculopathy. Well, we know that the best way to determine a radiculopathy can be in EMG and nerve conduction studies to show that there is some type of impingement of a nerve root, a cord, whatever the case may be. However, it doesn't always show up that way, and from clinical exam, a doctor can, make a diagnosis of radiculopathy. I saw a policy, this past week, and the carrier's escaping me, but it actually said evidence of radiculopathy as confirmed by EMG. So they're saying, hey, we require this. If it's not showing confirming, we're not going to, apply this exception to it. So you do have to be careful. If you do have chronic back and neck problems, a lot of people say, hey, I've got tingling in my, down my legs and into my hands, and you have one of these limitations in your policy, it would be a good idea to get, those nerve conduction EMG studies done so you can try to work your way out of that 24-month limitation, as opposed to sometimes people contact us after they've already been denied, and now you're trying to scramble to get that testing done. So it's just another built-in way for an insurance company to try to avoid liability. They look at mental health as a lot of times subjective, only you know how you feel. Well, that's how they're looking at pain, like we said. Only you know what pain you're feeling. They don't trust anything, so their way for them to alleviate their responsibility is having these limitations in the policy, which are perfectly legal. So you need to review your policy to see how they're going to look, what language they're going to use potentially to get rid of your case.
Right, and those are all great points, and a lot of people get surprised and they get this denial letter and they go, oh my gosh, I didn't even know that was in the policy. Mm-hmm. And if you don't know, if you know, you can be prepared for it. And there's lots of techniques and some of the things you mentioned where we can prepare you for it, and we've been able to help hundreds of clients to prepare for that limitation and get around that limitation so that your benefits can continue as long as you need. What we encourage you to do is contact Stephen, myself, any of our lawyers. We're going to provide you with an initial free consultation where we will review your disability policy. If you've been denied, we will review your denial letter and we'll let you know right away whether or not we can assist you. We represent claimants all throughout the country, so no matter where you live, we're happy to work with you and available to work with you. We encourage you to review our website, which is very unique. We have a lot of information about every single disability insurance company, information specific to your occupation, to your medical condition, as you can tell from this musculoskeletal video that we're doing. We even have specific videos about almost every single medical condition. We want you to review the summaries and articles that we've written about lawsuits across the country. The reason for us sharing this information with you is that we want you to be educated about the disability insurance claim process, because it's a type of game where if you don't know how to play it, you're going to be at a significant disadvantage. And the better educated you are about this process, the best chance you're going to have to get your disability benefits approved. So we encourage you to contact us for a free consultation, and we look forward to the opportunity to speak with you.